I spent 3 years and $73,000 restoring my grandfather's 1887 log cabin into a beautiful mountain retreat. 3 years of weekends, blisters, and sweat. Then, Carol Brennan, the HOA president, knocked on my door and said her son deserved to live there instead of me. She actually said deserved. When I refused to sell, she buried me in $17,000 worth of violations for a property that, as I was about to prove, her HOA had absolutely no legal authority over. The look on her face when the county attorney delivered that news was worth every penny. My name is James Whitaker. I'm 63, retired from a career in civil engineering, widowed for 5 years. My grandfather built a log cabin in the Blue Ridge Mountains back in 1887, long before the area became the upscale community of Ridgemont Estates. The cabin sat on 2 acres of pristine forest land with a creek running through the back corner. When Grandpa died in 2018, he left it to me. The place was rough. Logs needed rechinking, the roof leaked, the foundation had settled unevenly, but it had good bones, and more importantly, it had memories. Summer visits as a kid, fishing with Grandpa, my late wife Sarah sketching by the creek. I retired early specifically to restore it. Moved from Atlanta to North Carolina, rented a small apartment nearby, and spent every available hour on the cabin. I did most of the work myself, learned masonry on YouTube, hired specialists only for electrical and plumbing. Slowly, beautifully, it came back to life. The neighborhood had changed dramatically since Grandpa's time. In the 90s, a developer bought surrounding land and built Ridgemont Estates. Luxury homes, strict HOA, the works. My property became an island of old-growth forests surrounded by manicured lawns and Mediterranean-style houses. I'd met a few neighbors during construction. Most were polite, curious about the restoration. A couple even complimented the craftsmanship. Carol Brennan was different from the start. She was maybe 55, blonde, drove a white Range Rover with a HOA board president bumper sticker. I first encountered her in month 6 of renovations. She appeared at my property line with a clipboard. "You'll need to submit architectural plans for approval," she said, not introducing herself. "I'm restoring a historic structure. It predates your development." Her smile was ice. "Everything in Ridgemont Estates follows our guidelines. I'll email you the forms." I was too focused on work to worry about it. I figured she'd realize her mistake eventually. The cabin was finished in September 2021. Post and beam construction restored, stone fireplace rebuilt, modern kitchen tucked seamlessly into the historic structure. I moved in that October, finally home. 2 weeks later, Carol knocked on my door with her adult son, Brandon. Mid-20s, expensive haircut, entitled expression. That's when things got weird. Carol's smile was practiced as I opened the door. "James, the cabin looks wonderful. This is my son, Brandon. He's getting married next spring." "Congratulations," I said, confused about why this concerned me. "We were hoping to discuss a purchase offer. This property would be perfect for Brandon and his fiancée." I blinked. "It's not for sale." Her smile tightened. "Everything's sale at the right price. We're prepared to offer $400,000. The property was worth at least $600,000, but that wasn't the point. I appreciate the offer, but no, this was my grandfather's home. I'm keeping it." Brandon spoke for the first time. "Dude, that's not really fair. You don't even have kids. We're starting a family." The audacity knocked the wind out of me. "It's my property. The answer is no." Carol's expression hardened. "We'll see." 3 days later, I received a certified letter, notice of HOA violation. My cabin supposedly violated 12 different architectural standards. Roof color, window style, landscaping, fence material, lack of approved paint scheme. Total fines, $4,000. I called Carol immediately. "This is absurd. My cabin is historically registered with the county." "HOA covenants supersede personal preferences, James. Pay the fines or face legal action." I consulted a real estate attorney. He charged me $300 to write a letter explaining that my property predated the HOA and wasn't subject to their rules. Carol responded with another violation notice. This time, unapproved vehicle storage, my 1978 Ford pickup that I'd restored myself, unauthorized creek modification, I'd cleared debris after a storm, and prohibited firewood stacking. Another $6,000 in fines. She's harassing you, my attorney said, but fighting this in court will cost more than the fines. Sometimes it's cheaper to pay and move on. That felt like surrender, but I paid $10,000 to avoid legal fees. 2 months later, another notice. This time, Carol claimed my property was a fire hazard due to excessive tree coverage and demanded I clear-cut half my forest. Estimated cost of complying? $30,000. If I refused, the HOA could place a lien on my property. My hands shook as I read it. Those trees were old-growth oak and hickory. Grandpa had refused multiple timber offers over the years. Cutting them would destroy everything the property was. I attended the next HOA meeting in January. Stood up during owner comment period. Carol is abusing her position to harass me into selling my property to her son, I said, my voice steady despite my anger. This isn't about violations. It's about greed. Carol's face flushed crimson. Mr. Whitaker, your property is a liability to our community. These are legitimate safety concerns. Then why did your concerns start the day after I refused to sell? Several neighbors shifted uncomfortably, but no one spoke up. The board voted 4-1 to uphold the tree removal order. Carol abstained to avoid appearance of conflict, but her smile told me everything. I hired a tree service for an estimate, $42,000 to remove the specified trees. I sat on my porch that night, listening to the creek, watching moonlight filter through those ancient oaks. I'd spent $73,000 restoring this place. Now I'd lose almost that much to keep it, or lose the property itself to liens. Carol had won, or so she thought. February 14th, Valentine's Day. I was splitting firewood when I heard vehicles. Looked up to see Carol, Brandon, and the woman I didn't recognize walking onto my property. The stranger was taking photos with a professional camera. I set down the axe. Can I help you? Just showing Brandon and Ashley the property, Carol said breezily. Ashley is a designer. She's already planning the renovation. The fiancé, Ashley, was photographing my porch, my restored windows, my grandfather's hand-carved door frame. Something cold settled in my chest. You're trespassing. Oh, James, don't be dramatic, Carol laughed. Once the lien goes through and you default, the HOA can auction the property to recover fees. We're just preparing. Brandon deserves a home with character, and you've done such beautiful work here. She ran her hand along the porch railing, eyed sanded and refinished by hand. Smiled at me. You've essentially renovated our son's future home. We should really be thanking you. Brandon and Ashley were peering through my windows now, discussing furniture placement. I'd been angry before, frustrated, even desperate. This was different. This was white-hot rage mixed with crystal-clear clarity. They weren't trying to drive me out anymore. They'd already decided the property was theirs. I was just an obstacle to remove, a stubborn old man who didn't know when he was beaten. Get off my property, I said, quietly. Carol's smile didn't waver. Enjoy it while you can, James. The lien hearing is March 1st, 3 weeks. I watched them leave, Carol's Range Rover kicking up dust from my driveway. Then I went inside, opened my laptop, and typed 4 words into Google. Property rights predating HOA. If Carol wanted a war over legal technicalities, she'd picked the wrong retired civil engineer to fight. The first thing I found changed everything. North Carolina has something called grandfathered property rights. If your property existed before an HOA was established and you never signed the covenant agreements, the HOA has no legal authority over you. I've never signed anything. Carol had sent forms, but I'd ignored them, assuming they didn't apply to me. I spent that entire night researching. By 3 a.m., I'd found case law. Henderson versus Brookfield HOA, Martinez versus Sunset Communities. In every case, pre-existing properties that hadn't voluntarily joined the HOA were legally exempt. But I needed proof my property predated the HOA and proof I'd never legally joined. The next morning, I drove to the county records office, asked for every document related to my property and Ridgemont Estates. The clerk, a kind woman named Denise, helped me search. Here we go. Your property deed is from 1887, updated in 1952 and 2018 when you inherited. Clean title, no HOA covenant attached. What about Ridgemont Estates? She pulled those records. Development started in 1994, HOA covenant recorded in 1995. Your property isn't listed in their plat map because it was privately owned and not part of the development. So they have no authority over me? Not unless you signed their covenant agreement voluntarily. I never had. Next, I needed help. My real estate attorney was competent but cautious. I needed someone aggressive. A friend from my engineering days recommended Patricia Gomez, a property rights attorney known for fighting HOA overreach. I called her that afternoon. "They've been fining you for 2 years?" Patricia asked, incredulous. "And you paid?" I didn't know I had a choice. "Oh, Mr. Whitaker, you have more than a choice. You have a lawsuit." We met the next day. I brought every violation notice, every fine receipt, every email from Carol. Patricia's eyes gleamed as she reviewed them. This is harassment, abuse of authority, and possibly fraud. They've collected $17,000 in fines they had no legal right to impose. What do we do? First, I'll file a declaratory judgment action, asking the court to confirm your property is exempt from the HOA authority. Second, we'll sue for return of all fines paid under false pretenses, plus damages for harassment. Third, and this is my favorite part, we'll file a complaint with the state HOA regulatory board about Carol's conduct. How long will this take? The lien hearing is March 1st. I can have the declaratory judgment filed by next week. We'll request an urgent hearing before their lien date. There was one obstacle: cost. Patricia estimated $15,000 for legal fees. I'd already lost $17,000 to Carol's fines. I'd spent $73,000 on renovations. What was $15,000 more to end this forever? Do it. The urgent hearing was scheduled for February 28th, one day before the HOA's lien hearing. Patricia had worked miracles with the judge's calendar. We met at the county courthouse at 9 a.m. Carol arrived with the HOA's attorney, a nervous-looking young man carrying an overstuffed briefcase. When she saw me with Patricia, confusion flickered across her face. "What is this?" Carol demanded. "You'll find out," I said calmly. The judge, Honorable Margaret Chen, was maybe 60, with sharp eyes and no patience for nonsense. She reviewed our filing quickly. "Mr. Whitaker is seeking declaration that his property is exempt from Ridgemont Estates HOA authority. Ms. Gomez, your argument." Patricia stood. "Your Honor, Mr. Whitaker's property was deeded in 1887, over a century before Ridgemont Estates existed. He never signed the HOA covenant. Under North Carolina property law, the HOA has no jurisdiction over his land. Despite this, they've collected $17,000 in fraudulent fines and are now attempting to place a lien on property they have no authority over." The HOA attorney scrambled through his papers. "Your Honor, Mr. Whitaker's property is surrounded by our development. He's benefited from our community amenities." "What amenities?" I interrupted. "I don't use your pool, your clubhouse, or your roads. My driveway connects to County Road 47, not your private streets." Judge Chen looked at Carol. "Miss Brennan, you're the HOA president. Did you verify jurisdiction before imposing these fines?" Carol's face was flushed. "His property is clearly within our boundaries." "Geographic proximity doesn't establish jurisdiction," the judge said sharply. "Did he sign your covenant?" Silence. "Did you even check the property records before fining him?" "We assumed," Carol started. "You assumed." Judge Chen's voice could cut glass. She turned to the HOA attorney.
Counsel, do you have any evidence that Mr. Whitaker's property is legally subject to your client's authority? The attorney looked miserable. No, Your Honor. Then this is simple, Judge Chen signed a document with decisive strokes. Mr. Whitaker's property is hereby declared exempt from Ridgemont Estates HOA jurisdiction. The HOA is ordered to return all fines collected, $17,000, within 30 days. The scheduled lien hearing is canceled. Furthermore, I'm forwarding this matter to the State HOA Regulatory Board for investigation into Miss Brennan's conduct. Carol stood abruptly. This is ridiculous. He's destroying our property values. Your Honor, Patricia interjected smoothly, we're also filing a civil suit for harassment and intentional infliction of emotional distress. Discovery should be very interesting. I watched the color drain from Carol's face as understanding hit. She hadn't just lost this fight. She'd opened herself to personal liability. We'll countersue, Carol said desperately. For what? Judge Chen asked, genuinely curious. Carol had no answer. We're adjourned. The state board's investigation took 3 months. They found that Carol had violated 12 different HOA governance regulations, including using her position for personal benefit, imposing fines without proper authority, and failing to verify jurisdiction before enforcement actions. She was removed as president in May and barred from serving on any HOA board in North Carolina for 5 years. The civil suit settled out of court. Carol personally paid me $45,000, the $17,000 in returned fines, plus damages, plus my legal fees. Her homeowner's insurance refused to cover it because her actions were willful misconduct. I heard through neighborhood gossip that she and her husband had serious financial strain after the settlement. They sold their house in August and moved to Tennessee. Brandon and Ashley bought a condo in Charlotte instead. The new HOA president, a retired lawyer named Tom, personally apologized to me at a community meeting. Carol abused her authority and the board failed to check her. That's on all of us. You have our commitment, it won't happen again. Several neighbors who'd watched silently during my fight now stopped by to apologize. Mrs. Patterson from next door brought homemade cookies. I was afraid to speak up. I'm sorry. I forgave them. Fear of HOA retaliation is real. And Carol was ruthless. My property is quiet now. The ancient oaks still stand, the creek still runs. I've added a small deck overlooking the water, and sometimes my grandkids visit on weekends. I framed Judge Chen's declaration and hung it in my study, not as a trophy, but as a reminder. Legal doesn't always mean right, but right backed by law is powerful. The cabin Grandpa built in 1887 is still standing, and it's staying in the family. There's a lesson I learned through all of this that I wish I'd understood earlier. Don't assume people in authority actually have the authority they claim. Carol counted on my ignorance. She weaponized my assumption that the HOA must be right, must be legal, must have power over me. The moment I questioned that assumption and did my own research, her entire house of cards collapsed. If you're facing HOA overreach, neighborhood harassment, or anyone abusing a position of power, my advice is simple. Verify their authority. Check the actual laws. Read your actual deed. Consult an actual attorney who specializes in that area. Don't just pay fines or comply with demands because someone with a clipboard says you have to. Knowledge isn't just power. It's protection. If this story resonated with you, I'd love to hear your experiences in the comments. Have you dealt with HOA overreach? How did you handle it? And if you found this helpful or satisfying, consider subscribing to the channel for more stories about standing up for your rights when it matters most. Sometimes the best revenge is simply proving you were right all along.